who are not a party to the arbitration, those are the cases where we have suggested a change in the law that even though there are parties who are not a party to the arbitration agreement joined in the suit, despite that the court will refer the matter to arbitration. And unless court finds that the agreement is null and void, inoperative or incapable of being performed, the court will refer the parties to the arbitration and let the tribunal decide under Section 16. There is a suggestion to even make that order of arbitral tribunal appealable as in ancestral, so that the entire purpose of referring the matter to arbitration is if the tribunal has no jurisdiction, you don't have to wait till Section 34 to be able to challenge the award. At the same time, we have also said that unless expressly excluded, Section 9 and 27 would be applicable. The earlier word express was not there in the proposed amendment. We suggested that parties should be able to expressly exclude. So if in international commercial arbitration, if parties don't want Indian courts to interfere, only by way of a proviso to Section 2, the Indian courts will not have any jurisdiction if the parties have expressly excluded the jurisdiction of Indian court. Then we go to Section 34. There are number of Section 34s filed only because you get an automatic stay of the arbitral process and because of the wording of Section 36. So that has been proposed to be changed, as Justice Shah has said that there cannot be any automatic stay on that. The only difficulty is that the Law Commission has come, and with due respect, a Section 34 2A, where it gives a separate ground of patent illegality as the ground for challenge of a domestic award, whereas the public policy definition has come up for the first time. There is no definition of public policy so far. It's all judicially interpreted, and that's where we come up with these cases which are being referred in the earlier presentations, where the public policy has been defined narrowly, broadly, for international separately, domestic separately. But at the end of the day, the judges are faced with the question when we argue that this award, it needs to be set aside, and the question comes at that what is the definition of public policy, and that is the understanding of the judges, which matters a lot at the time of deciding what the public policy of India is. And this definition, which is proposed to be inserted in the Act, would definitely help and guiding factor to the judges when they are deciding rather than interpreting the cases of the Supreme Court. But if you are having a separate ground for domestic award, which is different from foreign awards, which is not there as a ground to challenge when we are coming for an enforcement, to oppose an enforcement, you don't have that ground. But when you are challenging a domestic award, you would have that ground of patent illegality that may cause some kind of a disparity, and it would lead to an intervention of the court. Because court intervention, as we heard, it has to be minimal. But yes, you need court intervention, but it cannot be that it only becomes like a stepping stone, and arbitral tribunal is replaced by a trial court, and then you start all over again with the court. So today the problem, what has happened is that we have not got an entire result of an arbitral process. Like we see it in other jurisdictions, India, we have not been able to do the arbitration in the right way. And rather than finding fault with all of us, we should think positively, use the technology. We can have online arbitrations where the technology has advanced so much that we can definitely reduce the time and cost. What we need is to change our mindset, change the law, start incorporating the right kind of clauses in the arbitration agreement at the time of entering in, because once you have a dispute, nobody agrees to even starting from arbitral tribunal's appointment till anything you will not agree. So that's where you have to start incorporating the right kind of clauses, appoint the right arbitrators and there is a perceived this bias and independence has become a big issue. And the question is that is there a corruption in the arbitration? You may not see it, but you can feel it. The perception matters when you are in any, it's a part of a natural justice. So you have to have an arbitral tribunal whom you believe, and not your advocate on the tribunal, but you need a real independent person on the panel of the arbitrator. So ultimately, we have to find from amongst us only, and we can definitely see that there is a bright future for arbitration in India, and we all need to work towards it. and hopefully we should, with the amendment in the law, which is pending for very, very long time, it is almost now 15 years that we have been talking about it. It's a time to implement it. And once it is implemented, we would be able to see a change in the entire system of arbitration. So with that, I would conclude my session. And if any questions are there, Justice Shah has said that we all can take the questions on his behalf. So please feel free to ask any questions or anything with regard to the amendment or any issue relating to arbitration. We would all be happy to answer. Thank you so much.
Have you looked into the report submitted by K Rao and the Law Commission Chairman?
Jagannath Rao.
Yes, yes, yes.
He has made a complete, he was the chairman of the Law Commission. Did you have an occasion to look into it?
Yes, in this report, it is based on that particular report and the further developments. If you see the 246th report, it starts with the history with the Justice Rao's report, and then it builds onto it. So that report is the basis of the new report.
Thank you very much, Tejas. We have a few minutes left, so I think if we can take perhaps 3 questions or 4 questions. Is there anyone who, apart from Mr. Bhatt's questions already been answered? Anyone else? Please, please.
How do you find an honest arbitrator?
My name is
Please announce your
Mallikarjun.
name.
My name is Mallikarjun from Karnataka.
Public policy.
I put a question to Raju Datta. So, lot of agreements we are coming to across. Can we put a arbitration clause in a sale agreement so that we can avoid specific for permanent suits and paying a court fee?
You can do it. There's no difficulty. You can do it. Because if there is a dispute which arises between the parties and you want the dispute to be settled by arbitration, why not? Why can't you do it? No, see the point is, it's basically, you all know today, and you know it will also depend, and I wanted to tell you this, it depends a lot on the lawyer that you approach. You know, it is the lawyers who we tell, we are the people who tell everybody that this is not going to happen. This is the way you should go about it. And let me tell you, specific performance suits with regard to agreements relating to properties in Delhi are a menace. And they are filed at the drop of the hat, and you know, these agreements which are entered into, and some money is passed on and then it is left for 2-3 years for the final sale deed to be entered into, is Delhi High Court is full of these. And what is the most important thing is, which lawyer can get you an interim relief? Now that's what is happening. But if the parties are there, they can choose between themselves as to, if a dispute arises, we will go to an arbitrator. The only problem that comes subsequently is that the arbitration awards earlier could not be implemented. But now everybody is thinking, and let me tell you, today the courts are absolutely flooded. You go to any high court, their judges are sitting till 4:30, 5 o'clock, and they are not able to finish their miscellaneous work. So the catchword, get an interim order and then hang on to it, is still prevailing and will continue to prevail till we develop an alternate dispute resolution system. It is absolutely true. Courts will not be able to handle it.
Thank you very much. Anyone else? Any more? I think we've heard enough lawyer bashing this afternoon. So, but now, if there's anybody else who wants to ask a question, it should be a purely legal question, please.
No,
Yes, ma'am.
No lawyer bashing.
Hello, I'm Shrija Chaudhary from ILS Law College, Pune, 4th year. I wanted to ask that under section 11(6), there is a provision where High Court can appoint the arbitrator when a party goes to the High Court. I wanted to ask, can the other party file any application or a review form that it is not according to his choice or something as that? Is there any provision as such?
When you go under 11(6), when both parties have failed to appoint an arbitrator, is it
No,
as
I
of
am putting up a situation where only one party has approached, the other party has no idea about it.
Other party would be heard before the appointment because the notice would be issued under 11.6, and that's where the delay is happening. Today, what is happening is that the appointment should be as soon as possible. But the moment the other party's notice is issued to the other side, they come, they object that there is no arbitration agreement or there is no dispute about the appointment, and that's where the entire delay is causing. As of now, it's only the Chief Justice or his delegate, which as per SBP judgment has been held to be a judicial power, has the power to appoint the arbitrator. And as we understand, it should be very simple process, is that you just go and appoint an arbitrator when you see there is an arbitration agreement. But what is happening in reality is that the other party comes, other party objects, there is arguments heard on that, and thereafter the arbitrator is appointed. So that is the delay in the entire process.
Can I just add? See, we should not forget one basic fact. Arbitration is consensual. It has to be on the basis of an agreement. If there is an existing agreement between the parties that in the event of a dispute will refer to an arbitration, then 11.6 will automatically bring that agreement in the forefront. So it's very difficult to get out of it. But if there is no agreement, I don't think the courts can force arbitration on you. I have appeared in cases today where high courts have interpreted that go for arbitration under 89. Supreme Court has said no, it cannot be done. Only mediation you can ask under 89, but you can't force a person to go for arbitration till there is an agreement for arbitration.
So another question, sir, if there is a civil suit already going on and if both the parties think that it is very tedious, so they can anytime switch on to arbitration.
The answer is yes, I think.
So I had another question.
Be existing dispute in writing, that they have to agree in writing.
So there is a settlement between them to go to arbitration. So it's a settlement.
It's a settlement.
The agreement is drafted during dependency to
Yeah, that's right. So now we have... yes, Mr. Vin, we know you.
Under the National Highway Act and Railways Act, there is a provision for arbitration.
Correct.
And there the arbitrator is appointed by the Railway Authority or MHI. And there also everybody will have to, the farmers who has lost his lands, there he has to pay the money. In our case, what has happened, I have filed one petition before the High Court, where every farmers will have to pay 5,000 rupees at initial stage. And at the same time, Railway Authority has also to pay rupees 5,000 per case. Now the arbitrator is a full-time government employee. He draws the salary, he is getting all amenities from the government, and there are 10,000 cases, if you multiply this by 10,000 to 10,000, how much amount he will get?
It will have to be read down. These provisions will have to be read down. In wake of the new act, they will be read down. You wait and see.
But now, so far, the cases which are pending.
Yeah, that is the problem.
Well, I think we are almost out of time now. Tejas mentioned his difficulty earlier on that by the time his turn came to make a presentation, most of the things he was going to speak about had already been presented or talked about. I think my difficulty in that way is even greater because I did not make an opening chairman's speech, so but I'm not going to keep you here very much longer, except to perhaps to tell you a story which I'm sure most of you already heard, but perhaps the students haven't, was that at a seminar, while the last but one speaker who was addressing the seminar, by the time he finished, everyone had left and there was only one person in the audience who was left. And then this chap had no alternative. He continued with his speech, finished it, and then he walked up to him and he said, "Thank you very much for your patience and consideration and for being here and listening to my speech." So he said, "Don't thank me, I'm the next speaker." Mr. Rehan for the vote of thanks, please.
Now, with the thanks of all the speakers on the dais, we concluded this session, and we hope that we will be in the valedictory session coming. And the tea is ready. that the High Chief come to.
Thank you very much.